Hello everyone, welcome to Streetlaw webinar. Today we are going to talk about employment law and COVID-19. My name is Eleni Caroz and I'll be joined by my colleague Kira Akana. We are both law students at the University of Hertfordshire.
Social distancing has been put into place for our own safety. We must remain 2 metres apart from anybody who does not live in our household. This is to reduce an increase of infection rates under the current situation with coronavirus. Social distancing has been introduced into our everyday lives, for example, going to a supermarket or in essential workplaces. Workplaces must ensure that government guidelines are being followed at all times. If you have any concerns about social distancing within your workplace, please make sure you raise these concerns with your employer. If you are working from home, there are many things your employer must still be doing. Firstly, your employer must ensure that you are still being paid in full. They must also keep in regular contact with you to ensure you are keeping healthy and safe and to check up on your well-being. What if I don't want to go to work? If you have any concerns about going to work, please raise your concerns with your employer. Whether it be you feel the appropriate actions have not been put into place to follow social distancing within your workplace, or it may be that you fall into the vulnerable category and need to follow government and NHS guidance for the period of time. If you are not feeling well or living with someone who shows the symptoms of COVID-19, please let your employer know. By law, all employees have the right to request for flexible working, including the right to work from home. Your employer must have a valid reason to refuse your request, such as it may not be possible. Preferably communicate with your employer via email so you have this conversation in writing. If you feel you come under the vulnerable people and those at risk category, or you have had a letter from the NHS and government, please speak to your employer about this. Your employers must be extra careful and take appropriate steps for anyone in their workforce who is in the vulnerable group. The government has made it clear that equality and discrimination laws are still in place, regardless of if you are working from home or still attending the workplace. When employers make decisions, they must ensure all employees are being treated fairly and not based on their age, gender, race, religion, disability or pregnancy.
Workers must receive any statutory sick pay due to them from their first day of self-isolation if it's because they have coronavirus symptoms, someone in their household has coronavirus symptoms, or they have been told to self-isolate for 7 days. The UK government has announced measures in order to help employers and the employees during this pandemic. The Furlough scheme was designed to help people put on leave due to the coronavirus outbreak, and to prevent employers having to make mass redundancies. The Furlough scheme will operate on its current basis until end of July 2020, but from August, employees who are under Furlough scheme will be able to work part-time for their employers.
Regardless of whether you work part-time or full-time, you are entitled to be furloughed, as long as you have been on your employer's payroll since the 19th of March 2020. If an employee has been on sick pay, they are able to be furloughed after their sick pay period. Your employer is allowed to pay you less than the minimum wage. This is because you are not working. However, if you are currently undergoing e-learning or training for your work, you are entitled to full pay.
An employer can decide to re-employ someone who was made redundant or stopped work for them on or after 28 February 2020, and then put them on furlough scheme.
If you work more than one job, you are still entitled to financial support from both jobs. You are also able to work for a different employer whilst being furloughed.
Regarding layoffs and short-time working, unless it says in the contract, employers cannot reduce or suspend their employees' payments. Employers in this situation should aim to be transparent with employees about the reason for the temporary suspension, as well as what potential alternatives might look like, including perhaps having to consider redundancies. There is a statutory scheme for layoff and short-time working, but a layoff clause in the employment contract is required in order to implement this. Regarding holidays, employers can tell employees and workers when to take a holiday if they need to. However, if you are on furlough scheme, you must get your usual pay in full for any holiday you take. Employees and workers should check their contract or talk to the employers to find out what they are entitled to.
If anyone in your household starts displaying symptoms of coronavirus, you must self-isolate for 14 days. If someone with coronavirus comes into work, the workplace does not have to close. However, they should follow strict cleaning advice. Employers should consider some simple steps to ensure they continue to provide their staff and customers the duty of care required.
Make sure you inform your employer about your concerns during this difficult period so they can address it immediately. Employees and employers can consider together all options available to ensure a healthy and safe workplace environment while avoiding redundancies. Both sides might need to make some sacrifices, and the employee needs to consent to any variation in their contracts, even if it's temporary. If you have any question about this presentation or about employment law, please contact our Streetlaw team. We are also on Twitter, Instagram, and LinkedIn. Please visit our website and also our blog page and learn more about the University of Hertfordshire Streetlaw project. Thank you, everyone.